Good morning and welcome. We will give everyone a couple of minutes to log in and then we'll get started. Good morning and thanks for joining us today. We'll give everyone a couple of minutes to log in and then we'll get started. I still see participants joining us, so we'll get started in about one more minute. Okay, we have a lot to cover today, so I will get started. Good morning and welcome. I'm Sonia DeLuca, your Associate Director and COO. Today, we will be learning about the legal reach of the governor's recent executive order dictating that if an employee contracts COVID-19, it is legally presumed to be a work-related injury. Our experts today will give an overview of the order, what could happen and the impacts it could have on your companies, as well as the legal aspects of the order, reporting, investigations, and what you can do as a grower and vineyard owner. We are thrilled to have our speakers with us today, Joe Martinez, President of DLL Insurance Agency, and Erica Rosasco, Partner and Attorney at McCaig and Rosasco. Thank you both for joining us today. But before we begin, I'll just go over a couple of housekeeping items. We are recording this webinar and it'll be sent out to you hopefully over the weekend, but definitely by Monday when we receive it from Zoom. You are all muted, so the best way to ask questions is through the Q&A box. You'll see that circled there in orange. The chat feature is for technical issues. So if you're having trouble seeing or hearing the presenters, send us a message there and we will try to help you as best we can. Our speakers will answer questions during the webinar as well as after. So continue to type in your questions in that box and we will get to all of them before the end of the session. If you're experiencing fuzzy or distorted audio, you can call into the webinar by phone. The number's listed there and the webinar ID that was also sent to you in your confirmation link. And at the end, we'll have a survey that'll pop up in your browser that we encourage you to take just a couple of minutes to give us some additional topics that you would like us to cover in these online educational seminars. So without further ado, I am going to turn it over to Joe Martinez from DL&L Insurance Agency. Thanks so much. So Joe, you can unmute and start your video and they'll be able to see you.
Okay, good morning, everybody. Sonia, can you hear me okay?
We can hear you, but we can't see you. So you can turn your video on as well if you can.
It says the host has stopped it.
All right, 1 second. Give us a minute. We'll get you live. Okay, we're having a little bit of technical difficulty with the video. So why don't you go ahead, Joe, and we will work on that while you begin the presentation.
Okay, good morning, everybody. I'm Joe Martinez, president of DLL Insurance Agency. Today we're going to talk about this overview on the executive order. We've had some cases that have happened in agriculture up in Sonoma, Napa, and also the Central South, San Joaquin Valley, and also down south. And so we'll chat a little bit about that. Eric and I will talk about that and how those have been handled. For right now, I'll get into this order, and then I will pass it on to Erica, and then we'll have some chat about the things that are happening in the industry. Okay, Executive Order N6220, issued on May 6, 2020, identified indefinitely by the Governor Newsom, established a rebuttal presumption for essential employees diagnosed with COVID-19, establishes the criteria for application of the presumption. Okay, now can you see me there, Sonia?
Yep, we can see you.
Perfect. Okay. The employee tested positive or was diagnosed with COVID-19 within 14 days after the day that employee worked at their place of employment at the employer's request. The other thing is this order takes place until July 5th. However, I have an understanding that that is going to change here soon. The day of work resulting in exposure occurred on or after March 19th, 2020. Number 3, there's basically 4 points that you have to meet. Number 3 is the employee's place of employment was not the employee's home or residence. And number 4, the diagnosis of COVID-19 was done by a physician who holds a physician or surgeon license issued by the California Medical Board. And that diagnosis is confirmed by further testing within 30 days of the date of the diagnosis. So those are the 4 requirements that an employee has to meet in order to have coverage under workers' comp. One thing that we do need to understand is that a lot of the insurance companies receive this order, but at the same time, they're already presenting rebuttals to that order. One of the things that positions of the workers' comp carriers is that these type of illnesses are not covered typically under workers' comp, and so this executive order kind of changed that. And so now what they're looking at is, hey, time out. Now that you've given a disorder, we do have to comply with this. We're going to challenge it based on different issues. For example, one of the problems that we're having, the next thing is important things to know is the employer's liability. The employer's liability is set for, it's part of your workers' comp policy. There's 2 parts of the workers' comp policy. There's the workers' comp, which typically covers medical and disability. The second is the employer's liability. And I put a description on here, which is liability insurance that covers employees for claims resulting from work or job-related injuries or illnesses that workers are not compensated or doesn't cover. An example, let me move the screen here. I can't see. Oh, here it is. Perfect. A healthcare worker becomes HIV positive, or in this case, let's just say COVID-19 from work-related contact with a patient. The healthcare worker illness is covered by workers' comp. However, if the worker's spouse then becomes HIV positive because of contact with the healthcare worker, the spouse is not entitled to workers' comp benefits. However, they are entitled to employer's liability. Now, the employer's liability is set exactly for that, in that and the employer received coverage for it, but now he brought it home, and now people at home all of a sudden have issues with becoming infected, or the employee cannot perform the same duties at home that he did before, and so now the spouse or those family members have the right to employer's liability. This is what I'm having an issue with, because if they get contracted at work and they take it home and somebody becomes seriously ill, now employer's liability will pick it up, and my fear is that that's going to cause bigger issues with employers having other liability issues. Exclusive remedy. The exclusive remedy provision in workers' compensation insurance states that a worker cannot sue an employer for a work-related injury as long as they receive benefits from workers' comp. So this is kind of this is very important, because if things get serious, let's say an employee is infected and it becomes very serious, they have some serious issues, or they pass away, the fear of some of our employers that we've talked to is, hey, listen, if they contracted this at work, and they're telling me that I'm responsible for it, how far can this liability go with my company? The important thing of workers' comp is that with exclusive remedy, the employer will not be held liable, because the first dollar that is paid under workers' comp, the employee can no longer sue the employer. And so I think that's very important, and that's something that we're going to fall back on if things do get serious. They ask questions. Can the employee use their personal health insurance for treatment? The answer is yes, they can, and it typically starts under that. However, it will, back up here again. Sorry about that, guys. Can the employee use their personal health insurance for medical treatment? Yes, they can. Initially, a lot of people are going, because there's a lot of free clinics that can provide the test with no coverage, with no charge, and they can go and they can have that test done. And so initially, when they go and they have the test done, they typically don't know for 2 or 3 days. Once they get a positive test, now they're bringing that to the employer, and the employer at that point has to make some choices about what they do going forward. What happens after the 14 days of benefits paid by the employer? So let's say that an employee does become infected. They do take 14 days. They're paid those 14 days under the new law. So they're going to be paid. Let's say that their medical coverage is done. Well, let's say that they go back for another testing and they're still positive. After those 14 days, then it would go into the benefits under workers' comp, and then they would be entitled to disability benefits after that. When do we report the claim to the workers' compensation carrier? And we think it's important to notify your carrier to put them on notice about somebody getting infected. However, the employer's responsibility is to make sure that they send that DWC-1 form to the employees, mail it to them, and it's their obligation to fill it out and send it to the carrier. Does the employee have to be paid even if they are not sick? If they are not sick, in other words, they do test positive, but they don't have any symptoms, yes, you do have to pay still. How difficult would it be to prove that exposure did not take place in the workplace? Eric and I had a conversation yesterday about this. I feel it's going to be very difficult to prove that. I mean, unless you're tracking that particular droplet of COVID-19, it's going to be very difficult. What is the estimated number of accepted COVID-19 claims in California? I don't have that figure when it comes to workers' comp. However, I can tell you that in our book, we're seeing we have probably 200 different labor contractors and vineyard managers combined. And out of that, I think we're at probably, there's 4 in a book of business we have, but I'd say overall, there's probably about 200. I just don't know if those have all hit workers' comp yet. It seems as though the packing houses are being hit in the San Joaquin Valley and other areas. And what are the estimated reserve for the claim? So we had a conversation with a TPA yesterday, and at this point the reserves are very low. The reason is that the claims are coming in, they're being reported, however, there's no cost to the claim. In other words, the employee is going to a doctor, to a clinic, the clinic is testing free, they find out about it, they're going home, they're like a flu. In other words, they're not going back to the hospital or follow-up visits to the doctor. They're basically waiting the 14 days. The majority of them are coming back. So the reserves have not been very high. Well, thank you for that. But another thing I do want to mention is that one of the questions that we've had is, okay, so we report this to workers' comp. The workers' comp is going to take it and they're going to set some reserves on it. How is this going to affect my workers' comp in the future? In other words, if I end up having a packing house of people, or let's say a crew that has it, and we have 15 or 20 employees that we have to send home and we have to open up claims for 15 people, how is that going to affect us? So one of the things that the governor said is that this is really isn't going to affect your XMOD. They're going to work with WCIRB, which is the Workers' Comp Insurance Rating Bureau. However, it is going to be an issue in that when an underwriter looks at your workers' comp, they're going to look at your loss runs and they're going to see 15 cases, whether they be minor or not, they're going to see 15 workers' comp cases. The problem is that yes, this order is only good till July 5th. However, we don't know what's going to happen next season or next year. And is this order going to extend, or is this going to be the norm going forward? So thank you, and I will pass this over to Erica.
Thank you, Joe. Okay, I want to talk about a couple of things that I think are going to get lost in this process, because we've starting to hear the grumblings of the fact that this may be a workers' compensation claim, but there's a couple of other important things that are cropping up that I want to make you aware of, because OSHA is going to be very, very busy in the coming days. And a lot of these things typically go in tandem with one another. I was chatting with an OSHA investigator week before last, and I asked them, how things are going. And they said that they have currently over 2,000 complaints from employees related to COVID. So typically that would be an employee calling and complaining and saying, hey, my workplace is not safe. So now under new laws that actually went into effect January 1, had no idea this was going to all come about, right? OSHA is going to be required to investigate all of those complaints that basically have any merit whatsoever. So with that, you've got an employee who potentially got sick at work. You've got to consider two other things. Do I need to record that COVID-related claim on your OSHA 300 log? And do I need to report that to OSHA? And the answer on the recording is yes. You do need to put that on your OSHA 300 log if that work-related fatality or injury, illness, in any way could be work-related and results in death, days away from work, so outside of that first day, right, days away from work, transfer to another job, medical treatment beyond first aid, loss of consciousness, or significant injury or illness diagnosed by a physician or other licensed healthcare professional. So COVID-19 has already been determined to be a significant injury or illness. So you're going to have to consider putting that on your requirement. So in California, the director, their new head of OSHA has come out and said, look, we're presuming that COVID-19 cases are work-related if any workplace exposure is identified, even if it's more likely attributable to a non-workplace exposure. So once you have any type of positive testing or sick employee, that's considered enough. So anybody else who rolls from that is going to be considered to be a recordable incident. To even further clarify from that, there's you can go on and see now there's like an FAQ section that the Labor Commissioner's Office posted, and the new head of OSHA posted saying, look, OSHA is recommending that you err on the side of recording, which is not going to make any of us happening. So you don't have to have a positive test for COVID in order to trigger that recording requirement. So them being sick and having symptoms is enough. And to determine whether there's been a workplace exposure, so whether it's possible that this occurred in the workplace, that person has to have had interactions with somebody identified with the virus at any distance and any duration so far. There's been no specification on that, even if it's from 20 feet away. They were working in the same area with somebody known to have been carrying the virus, or they were sharing tools, materials, vehicles with that person. So riding in the same vehicle to work would be enough. And they don't tell us how we rebut that presumption when it comes to recording. So they want us airing and putting it on our OSHA 300 log. Now, here's the sort of saving grace. If there's no known workplace exposure, so nobody's tested positive, nobody else is sick, this appears to be an outlier, we tested the employees around them, they all came up negative, then you might be able to skip the recording if you then can say, okay, look, this employee was having no contact with other employees, everybody was spaced out, they don't have contact with the general public, physical distancing was maintained, and that one didn't come, the employee didn't come into contact with anybody that's had any symptoms. Then you're allowed to step away from that and say, okay, look, I'm going to decide, with a little bit of risk, because we know how OSHA is going to come down on the subject, that it would not be recordable, but at least you're in a defensible position. So if your employee spends time in quarantine, that alone is not going to be enough to trigger recording. So I know with some of my employers, the minute somebody shows symptoms, we stop everything, right? We send people for testing and we quarantine them until we get the test results back, because we don't want to potentially infect more of our workers, knowing now that we've got this workers' compensation issue at play. So that alone is not going to trigger. So if you have a crew of 20, one person has symptoms, you're not going to have 20 people on your list just because we quarantine them. It may very well be that none of them end up having it. Now, the second component of that, and this is the one that they love to issue citations for, right, is reporting this to Cal OSHA. And just so you guys know, oftentimes we will mess this up, right, and we won't report it to OSHA, or we don't even think it's a reportable incident, but OSHA figures it out and ends up at our doorstep. Well, how does that happen? Our hospitals, our first responders, all those folks, whenever they think something is work-related, they are calling OSHA and notifying them, even if it wasn't something that we were required to report, and they're ending up on our doorstep, and they're going to want to see our logs, right? And they will absolutely issue a citation for that 100% of the time if we should have called and didn't. So when do you have to call OSHA? This has changed this year. So if the employee has an inpatient hospitalization for any period of time, it's not 24 hours anymore, outside of getting some testing, an actual hospitalization where they're admitted for any length of time, it becomes reportable. Obviously, if that employee dies, it's reportable. If we think there's in any way, shape, or form that it could have been related to the workplace, unless we have absolute certainty it did not, right, it's going to be reportable. If they come down sick in the workplace, it's reportable. And that's the really tough part that's hard to swallow. So you have to report it to your nearest Cal OSHA office immediately, but no later than 8 hours after we knew or should have known with diligent inquiry about the illness or injury. So if you hear of an employee who's going into the hospital, if you in any way think that that might be reportable, you're going to want to follow that very closely so you meet that reporting deadline. Where there's uncertainty about whether the employee contracted COVID-19 at work, the employer should err on the side of reporting. I know that's painful, but that's what they're telling us. If the employee becomes sick at work, but the illness is absolutely not work-related, we have to report it, right? It's a serious illness or injury occurring at work, and we don't make a determination about whether it's work-related. So this is where it gets important. We're going to talk about investigating. You're going to want to figure out right away when that employee first showed symptoms, because a lot of times they'll tell you, oh, I first started feeling like I had allergies at home. Great, that gives us something, right? But if they're first showing symptoms at work, that makes it reportable, which is a harsh result considering that we know, it has a long incubation period. So if they're showing outside of work, they're still telling us we have to err on the side of reporting. If there's any cause to believe the illness might be work-related. So regardless of whether the onset of symptoms occurred outside of work or not. Now, how does that come up? How could that, be that maybe we don't have to report? Let's say they have been out of work for a few days. While they're out of work, they start showing symptoms, and it turned out their spouse had it before them. Okay, I think now I feel like there's cause to believe it didn't happen at work, right? We've got no other sick employees. Maybe they worked by themselves. They were a tractor driver. They only touched their tractor. Nobody else did. Then I'm feeling more comfortable. I'm saying, look, that's a defensible position of not having to report it. But if you don't want to have to deal with the citation, you're going to have to call. So keep in mind when you call, they're going to end up on your doorstep. They are expecting us to have our IIPPs addressing COVID-19. It's now a known workplace hazard. And I think probably 99% of us haven't done that. And they'll issue a citation for that as well. And I know some of you have heard OSHA's only issued one citation so far related to COVID-19. Don't rest on your laurels thinking that they're not going to be issuing citations. They have 6 months to come back and issue that citation. And quite often they do it right against that statute of limitations. So be careful there. Do you have to report an illness even if it hasn't been diagnosed yet? Of course, yes, right? Even if it's a suspected case and it hasn't been diagnosed yet, and there's any connection to employment, right? They're showing symptoms first at work, or they were around somebody else, and it resulted in death or inpatient hospitalization. It does become something that you have to report to OSHA. So Joe was talking about earlier that work comp presumption, so I don't want to go through that again. I do want to mention that antibody tests are enough on your work comp side. So switching back to it being a workers' compensation claim, antibodies tests are going to count because the idea is the person's had it, and it may be that they didn't get around to testing until they had already recovered from it. So antibodies tests are going to be enough. And if somebody was asking earlier about more information on that DWC1 claim form, so within 1 working day of receiving knowledge of an injury, 1 working day, that time is lost beyond that worker's actual first day shift, right? That results in medical treatment beyond first aid. The employer has to provide that employee either personally or by first class mail that form. It then becomes up to the employee to decide whether they want to report that into work comp. And I will tell you, I've seen many cases related to COVID-19 where the employee did not. They did not wish to file a claim. But we have to do our due diligence and make sure we're keeping track and documenting that we sent them the DWC1 claim form when we should have done it. Couple other things I want to make you aware of that are related to this is 2 other claims in this one. Now that we're in work comp and it's a work comp claim, there are 2 other claims that employee can very easily file for that most people are not familiar with. One is a serious and willful claim. So what this does is it takes that employee's claim, and it increases their benefits by 50%. So if your employee ends up with COVID-19, they get on a ventilator, they're in the ventilator for 6 weeks or 4 weeks, or their organs start failing, if they have a very serious case, you could be looking at potentially $1 million workers' compensation claim in total, right? Those are the worst cases. Then you're looking at an exposure of $500,000 that cannot be covered by any type of insurance. It cannot be covered by insurance because it's considered willful. In order for them to have this claim, and sometimes I will tell you they file the claim because they're looking for more benefits. Workers' compensation, they believe, undercompensates employees, so they do it as a means of extracting a larger settlement from the employer. But in this case, the employer has to know about the dangerous condition, which everybody knows about COVID-19. Everyone knows we have workers working together, right? We know about the probable consequences. We've all seen it. And we deliberately fail to take corrective action. So this becomes important that we rely on our safety programs, our training, our diligence in enforcing those rules. Otherwise, we could end up with a serious and willful claim if we fail to provide the safe environment for our employee, or we violate a safety order. And this is for any workers' compensation claim that they can file this. The 132A claim, that's the other claim that they can automatically file in workers' compensation. And what this is, if we discharge, if we threaten to discharge, if we discriminate against an employee because they have filed or intend to file or wanted to file a workers' compensation claim, this one could potentially be covered by an EPLI policy, your employer's practices liability, if you have one. Those tend to have very high deductibles. They're very expensive policies, but if you have one, you would want to turn this into that. With this claim, 132A, the employer can be guilty of a misdemeanor, and also they can get increased benefits by up to half, but no more than $10,000. So it's very easy to hit that $10,000 mark, and then another $250 in costs. But here's the kicker. As long as that employee isn't offered their job back, they're also going to be able to claim back wages and benefits caused by the discrimination. So how this comes up is we go to do our seasonal layoff, we lay people off, and they claim a 132A claim. So don't stick anybody that you think has filed a workers' compensation claim into a layoff if you wouldn't have normally done that. Let's see. Investigating work comp claims is the last thing I want to make sure we cover, because your workers' compensation carriers are potentially going to be very, very busy with these workers' compensation claims, and our window to investigate is only 30 days. And I'm sure Joe can talk about there are ways that they can get beyond that, but we've got 30 days to investigate that claim. And so depending on who your carrier is, you may want to venture to investigate that yourself before you lose valuable information. And it really starts with documentation, right? You normally should have a workplace investigation form. You want to start there, especially while you still have access to that employee. They're not in the hospital yet, right? We want to talk to them about it. This is probably something that's going to occur on the phone and not in person. Nobody wants to be around somebody who's sick or potentially sick. You want to interview that employee while things are still fresh in their mind, and ask them, do you know where you got exposed? Sometimes employees are pretty forthright and they'll tell you, yeah, my mom has it. Yeah, my spouse has it. Yeah, my kid has it. They got it from so-and-so. Oh, we went to a family barbecue and everybody got sick. So we document that, right? You want to know if that employee was doing their regular job when they got sick, or were they doing something else? Get as many details about the potential exposure that you can. If they know, they might not know, right? You want to confirm whether that occurred in the course and scope of their employment, or were they doing something else? If at all, possible, do we know? You want to ask them if they, who else is aware of their illness, because this is going to be people they told about how they got sick or where they might have gotten the exposure from. It leads to potential witnesses later on. At this point, that's where we probably have to stop in a COVID-19 case because of privacy concerns and HIPAA concerns, but ask while it's fresh in their mind and before it's 2 years down the road when this claim is still pending, right? You want to obtain the names of all of their coworkers that they might have come into contact with within 6 feet, because we potentially need to quarantine them. We potentially need to test them. We need to take action. We're going to be disinfecting things. We're going to be informing employees that they've had a potential exposure. We're never going to tell them who. Remember, this is a medical case. Anything medical related, we keep in a separate file. It's private information. We don't disclose it to others. We want to make sure we ask this employee, what have they been doing over the last 14 days? They're going to remember now. They're not going to remember 2 years from now. Ask them where they've been treated at, right? In those medical records, you will often find information, or the insurer will, where they got exposure. They'll tell their doctor where they got the exposure, but they're not going to tell you. So it becomes very valuable information for us. So get anywhere that they've treated, we get that information so we can pass that along to our carrier. Review with the employee what we're going to do to assist them in their recovery. That keeps them happy, it keeps them not filing a 132A, it keeps them not filing an S&W, right? And reinforce that they need to keep back in contact with you, right? If we're giving you an update on their recovery. For temporary disability benefits, I believe they have to report back every 14 days, if I'm not mistaken. And I know Joe will correct me if I'm wrong on that. So in this, with COVID-19, it becomes even more important that we check back in with them. You want to know who this employee resides with. Who are they riding to work with? Who are they sharing meal and rest periods with? Has the employee worn company PPEs? If we're providing people with masks, did they wear them? Have they maintained social distancing, or was this the person that we had problems with, right? Is this the person that we had to repeatedly ask to please wear the PPEs, the masks? Do they have a job which does not allow for social distancing? So like in our packing houses and our meat packing plants, it's been really hard to maintain that social distancing, and we've seen outbreaks. Has the employee been to any social gatherings in the last 14 days? Have they been to a funeral? We did have one case that we believe was linked to the family having gone to a funeral and everybody ended up sick. Have they been to any stores or markets? Have they visited any friends or relatives? Have they been to a place of worship, protests, right? Sometimes we'll see things on social media. They're at a protest, they're not wearing a mask, they're, a foot, away from other people. Have they been to beaches or campgrounds? And do they have a second job? Sounds, crazy, but we have a lot of people who have second jobs. Yeah, on the weekend, I'm, whatever it is, where they would have been in close contact with people. And then we want to make sure we're paying them right. That first 14 days are going to fall under the Families First Coronavirus Relief Act sick pay, where they're going to get 100% of their pay for up to 80 hours of time before that temporary disability benefit is going to kick in for them. We always want to learn from our mistakes, right? So is there anything that happened here with this employee that we could have avoided the exposure? Do we need to stagger shifts? Do we need to start people 30 minutes apart so we have smaller groups going to their meal and rest breaks at the same time, right? So we have plenty of shade for them. So learn what we can do for the next time. And you want to ask the employee, is there anything we could have done? Is there anything we should have done? Is there anything you've noticed that we could do better? You can ask the employee to do a recorded interview. If you feel confident in your interviewing skills, it does help keep an accurate record. Sometimes I'm in favor of these. A lot of times I'm not. When it comes to farm workers, it may actually make them not want to talk to you. So I would err on the side of getting the information rather than worrying about it being recorded. Obviously, they're not going to be doing a written statement because we're not going to want to see them in person right now. Be polite, be courteous. Don't be accusatory. Again, that really leads to people filing lawyering up and filing an S&W and filing a 132A. You don't want to offend them if they have a legitimate claim. And you also want to make sure, just as a matter of practice, you investigate all work comp claims, right? So you're doing it consistently and across the board, so you're not singling anybody out. And you can let people know in advance, hey, look, guys, we have a new policy. We investigate our work comp claims. Don't be surprised. It's nothing, against you. It's not that we don't want you to report it. It's we want to learn from our mistakes and how we can keep you safe, right? Another important thing, especially with our workers, is what other members of that household work for us. Have there been any rumors about exposure, right? We've got a case pending where there are rumors, and we know the employee's not being truthful because they had previously disclosed exactly where they got it, and it wasn't at our place of employment. This was somebody who'd worked off by themselves, and it was very unlikely that they could have come into contact with COVID-19 during the workplace. So what do you do if you hear rumors about your employee out partying on the weekends and not adhering to social isolation orders? You want to make sure you let your carrier know that when you go to report the claim, so that they know when they're doing their investigating. And then when you interview the employee or the carrier does, you're asking them, hey, we heard that you've been out partying in the weekends, that you've been, in close contact with other people. Is that true? And see if they are honest about it. So the other big thing about this is there's a stigma attached to COVID-19. People are coming to work sick. They're not telling people they're sick until they get really, really sick. They don't want other people to know. They're afraid to have that stigma attached. So you want to keep things very private and safeguard, their medical information so that it doesn't get out and nobody identifies who that person is through anything that we have done. We're already seeing a lot of employees complaining about that. And be careful when you're doing your investigative documents. Keep in mind, everything you write on there, it's going to be read someday. It's discoverable. So don't put anything in there that you wouldn't want your employee to see or their attorney to see later on. And with that, I'm going to go back to, and I think we're ready for our Q&A session. Let's see, so I can stop sharing. Sorry, technical hiccups on how I stop sharing. There we go. Screen share, stop share. Okay. We did get one question. Is employer considered hospitalization for Cal OSHA? Not sure exactly what you mean, but if the employee gets admitted to the hospital beyond just diagnostic testing, but actually admitted for any period of time, then that is going to be reportable over to OSHA.
One of the things I wanted to mention is that when you send that form to the employee, it would be good to certify it, to make sure we get the employee's signature to verify that they received the DWC-1 form.
Right, because Joe, there's a penalty if we don't get that to them, right?
Correct. Is it penalty again? Yeah, if they don't receive it and then it is compensable, they would just receive, they would be compensated disability and medical, whatever the limits are, until that injury is, until that illness is corrected. So we couldn't dispute it at that point. The other thing is that in order for them to continue to receive disability benefits, they would have to go back to the doctor and get a disability slip from the doctor every 15 days. Typically it's 45 days, but in this case with COVID-19, it is 15 days. So let's say that the employee is infected and you paid them their 14 days. Now they work comp disability, they would have to go back to the doctor and they'll issue them disability form.
Yeah, the other thing I forgot to mention about investigations is if we discover new information after that 30-day period, that can also be used, but it has to be new information that we didn't have before, we couldn't have gotten before. So if rumors crop up after 30 days, you would still want to let your workers' compensation carrier know what's going on so that they can investigate. Everybody's quiet. Any more questions?
Can I ask you a question?
Sure.
No, I'll go back off.
So I'll have so my question is, and we've had this conversation is, let's say that we have somebody in the crew that is infected, right? What is our responsibility to the rest of the crew, to the rest of the people that work in the crew and the supervisors? What's our responsibility? Do we need to notify them? Should we have them all checked? Do we send them all home? I know we've had that conversation. Do you want to elaborate on that?
Yeah, what I am telling my clients to do is once we know somebody's potentially infected, to stop it right there and keep our liability as low as possible. We're not only sending that employee for testing, we're also sending anybody that was around them for testing and quarantining them until we get our results back. I know one of my clients had called and they were like, gosh, it's going to be, 5 days before this person can get tested. And so I said, nah, there's plenty of places out there that can do testing and get it back right away. Call around and get somebody else. She called that night, and by the next morning at 7 a.m., everybody was able to get tested. So there are plenty of tests available out there. And you might want, it's well worth the time and energy to get them tested right away so that you don't have people out on quarantine unnecessarily. And then of course, all of that time that they're out on quarantine, we're paying them under that up to 80 hours of time off. So, and we want to keep that down as much as we can, right? Suggestions for daily routine for employees when they come to work. Yeah, so we are still recommending, and it's still appropriate to do temperature checks and to screen employees when they are coming to work. And we have found with the temperature checks that there are people showing up to work with fevers. And to me, it kind of goes back to that whole stigma thing, right? They want to keep working. They don't want anybody to know. They aren't really sure of the process. And so we are doing that, but we're also having to do that in privacy. So you can't hear what's happening or see what's happening with another employee when they're checking in the morning, and that is all compensable time. So all the time that we spend doing that, they're on the clock, and then going over our social distancing, the sanitation of commonly touched objects, hand washing should be reviewed frequently. And then also with heat illness, right, we want to make sure we're putting up more shade. We had another heat wave this week. You've got to have enough shade up that you're allowing people to socially distance, or I'm staggering the start of my crews so that instead of everybody starting at 6 a.m., maybe I have a crew start at 5:30, 6, and 6:30. So I'm further breaking folks up from one another. And then if we see people, obviously what they do on their lunch and rest breaks are duty free, and we're not supposed to interfere with that, but I would still educate them about the dangers of COVID-19 and that if they are going to be that close, they are potentially going to get sick. Now, if they're on their meal and rest breaks with people they already live with, that's not so much going to matter. They're going to be exposed. They're essentially sheltering in place with them anyway. But that's what I would suggest doing. Any other questions for us?
I don't see any coming up. So thank you both so much for participating today. I just want to reiterate that we are here to support all of our members, growers and vineyard managers in NEPA, to keep our workforce safe and healthy during this pandemic. So we have a lot of resources on our website. So I encourage everybody to continue to check there. We do have an IIPP addendum that addresses COVID-19 that you should all take a look at if you haven't. We did that in conjunction with AgSafe. So you can look for that and make sure that you have that up to date and that you have done that for your company. We also have free masks for all Napa County farm workers. So if you haven't placed your order or replaced your order, please do so with us. You can do that on our website or email any of us on staff directly, and we can get those out to you. So, oh wait, do we have one more? Looks like we might have one more question. Yes, we have recorded this. We have both PowerPoint presentations from Joe and Erica, so we will be sending this out to you all with the follow-up along with the resources that we have for you. Safety protocols in the workplace, best practices that we should all be using, social distancing signs that we have throughout the county. If those make sense for your operation, we're happy to deliver those to you as well. Thanks again to Joe and Erica for sharing your expertise today. It's really helpful as we all try to navigate these not only uncertain times, but times that seem to be changing on a daily basis.
Every day. Every day. Yes.
Every day.
Stay tuned because it'll change tomorrow.
Exactly. So if you all could stay on and please do the survey that pops up in your browser, that's super helpful for us as we continue to provide education during these times in the 2020 growing season. So thanks again. Stay safe and healthy and have a great weekend.
Thank you.